Good evening, everyone. Do we have any doubt from yesterday? Why you all are so low on energy? Huh? I low on energy? 11:30 say. Just 11:30. I have been taking class since 8. Oh. And I wake up at 7:55. And I have class at 8. So, we have any doubt? A or 4 only. Yesterday I told you, now we will discuss it when we feel we are confident in polity. Yes, remember? Because if I will discuss Nagaraj case, if I will discuss the consequential seniority, if I will discuss what is the carry forward seats, then you will be confused and you will feel demotivated. Because we need the base. So, and who took the responsibility of reminding me? Someone become a volunteer and take the responsibility that they will remind me. Okay, you take the responsibility of reminding me that before the last class or the second last class, you will remind me to teach the 16.4a(b). Okay, very good. Yes, yes, please.
So for Article 14, we have like for equality before law is like it is talked about again. For equal protection of law is
Equal protection law is type of a right, that it is a type of a reasonable restriction only to establish equality. Question. This was the revision. Okay. The thing is, do not go that much deep into it. Whatever we discussed in the class, whatever we wrote, if you remember that, that will be more than enough for answering the questions. It's just that I need to tell you something more. So that if I tell you 100 things, you remember 80. If I tell you 80 only, and you will remember 50. Okay. So that is why I am telling you something more. Do not get into this that this is a right or reasonable restriction, right or reasonable restriction. Just remember whatever we have discussed. Do not go too much deep into it. For that, we will have mains. Right? For prelims, you just need to have a knowledge. You have seen the previous year questions of UPSC. Even if you have a slight conceptual idea about it, the clarity is needed. But if you have the clarity and that too limited, you can solve that question. UPSC is not confusing you. UPSC is not giving the answers in such a manner that it is 1, 2, 3 or 1 and 3. If you know that second is correct, definitely there is an option. And when you know it is incorrect, definitely there is an option. We will see certain questions like this. Okay? Very good. Any other doubt? Yes? No, that has also been identified. There is something which you are discriminating, or the grounds on which you are discriminating is because of someone's birth. That is untouchability. Leprosy is a disease. People are boycotting because of disease. Or if a person is an alcoholic, a person is not alcoholic by birth, generally. Okay, generally we consider. We do not know, exceptions can always be there. But if a person is alcoholic and society is boycotting, so that is a social boycott. But if a person is born in a particular gender, a person is born in a particular caste, person is born in a particular community, when people are boycotting it, him or her, it is because of their gender, it is because of their caste, it is because of their religion, it is because of their community, then it is untouchability. Is it clear? Something which you have done and you are being boycott, you are facing a boycott because of it, that is not untouchability. For example, if a person has, let us say, take an example, if a person has committed a crime, right? So what people come? People come and write Gaddar in front of their houses. That we have seen in Chakde. So that was a type of a social boycott. Okay? Understood the difference? The question that may come is whether it is defined in the constitution or not, whether it is defined in the act or not, whether it is an absolute right or not. That's it. Because what questions are coming? Identify which type of right is this. Even this much you can do, that is more than sufficient. Clear? Very good. Shall we proceed? So we have completed till article 19, right? Article 19. Now after 19, what we have to do? Article 20. Now article 20 protects you from what? It is a freedom. It is protecting you from certain type of convictions. A person may or may not be convicted in all the circumstances. There are certain protections. Now this is available for all or only for citizens? 20. All. It is available for all, because now you have the cheat code 15, 16, 19, 29, 30. So it is available for all. It is very simple. It says no ipso or no ex post facto law, no double jeopardy, and no self incrimination. This is what is mentioned in article 20. Is that clear? No doubt? Any doubt in this, or it's clear? Yes or no? Please tell me. It is simple. No ex post facto law, no double jeopardy, no self incrimination. Shall we proceed further? रट लेना उसको. Yes, no? No. ठीक है? Because we are here to understand things. Polity में, in Indian polity, do not cram anything. कुछ भी नहीं रटना है. ठीक है? कुछ भी नहीं, सब समझना है. क्योंकि रटने बैठे हैं तो फिर क्या फायदा, तो घर पे बैठ के रट लेते. Right? So we'll understand each and everything. What is ex post facto law? ठीक है? जो नॉस्टैल्जिया में चले गए, एक्स सुनते ही वापस आ जाए. Okay, it is different. It is the understanding that a person cannot be convicted for something which is not a crime when that action was done. It means you can only be punished for doing something which was a crime when you committed it. Let us take a very simple example. There is a prohibition of alcohol in Bihar, right? Now let us assume the date is, it was somewhere in 2015. Right? Let us assume the date was, which date do you want to take? 14th February, because most of you will be sad on that day. So let us take 14th February. So that day you are having the prohibition on alcohol in Bihar. We are just assuming it. Okay. Now if you are consuming alcohol on 15th of February, will you be committing a crime? Yes. But if you consumed alcohol on 13th of February, right? On the 13th of February, you consume alcohol and you were arrested on 15th of February. Will you be punished under that conviction? No, because it is no ex post facto law. Is it clear? It means you will get only punishment for a crime. But on 13th of February, consuming alcohol was not a crime. समझ में आया? Second thing, that you cannot be punished for a crime as a punishment more than the punishment which was given when you committed that crime. For example, you have committed a crime. Let us say 2019, the price for the Motor Vehicles Act increased, the violations of the penalties for driving rules increased. Now imagine you were driving on 31st of July, okay, or let us say 30th of September, because they were valid from September or October someday. So a day before you are driving and you jumped a red light. Next day you got a challan. So before that, jumping a red light was for 100 rupees and next day it was for 1000 rupees. So you will have to pay how much? 100 or 1000? 100 rupees. Clear? Because you cannot be paying the penalty more than that which was identified at the time of conviction. Is it clear? Ex post facto law is clear. Very good. No double jeopardy. It means you cannot be punished for a crime more than once. You cannot be punished for a crime more than once. One crime, one punishment. Is that clear? Simple? Very good. No self-incrimination. It means you cannot be forced to be a witness against yourself. That you see na, in the movies, in the third degree torture person, or in CID, Daya slaps person directly into the interrogation room. Yes? So and say, tell me you were there. Batao tumhi the. So the person can say, according to Article 20, Clause 3, I will not tell. Because there is no self-incrimination. This is the right. But there are certain reasonable restrictions. You may say that there is no ex post facto law. I will not be paying taxes. But you have to pay from the back date also. Otherwise, crime is when you are caught. There are certain limitations also that after that date you cannot have a complaint. But here the protection is only for the criminal acts. Criminal acts. The protection is for the criminal acts. Clear? Second thing, no double jeopardy. Now, let us take an example again. And now I have to also tell, do not take it personally. Whatever I am discussing, do not take it personally. We are only here creating fictional stories to make you explain. Now, if a person is committing domestic violence, a person is doing domestic violence, that is a crime. Police comes, right, and that person is jailed. Now, while the judicial inquiry is going on, the person is also a student of Constitution. The person say, Judge Saab, I will not be going to the jail because there has been general jeopardy. They say, what happened? Her brothers came and they beat me. So the Judge Saab will say, the double jeopardy is only available when there is a judicial punishment. In addition to it, any other punishment may be given. It's not only brothers. Some ex may also come and beat you. कि तुमसे शादी वाले दिन बोला था, ध्यान रखना इसका. So that will not be double jeopardy. Double jeopardy includes only judicial punishment. It means a judge cannot give two punishments. There will be only one punishment. But if there is an administrative inquiry, that is not double jeopardy. Example, very simple example. A person is caught taking bribery. A person is caught taking bribe and the person will be charged under Prevention of Corruption Act. Now that person will be sent to jail for 3 years, and in addition to it, the person's job will also be taken. The person will be dismissed from the services. So that will not be counted as double jeopardy, because one is judicial action, another is administrative action. Clear? Clear? No doubt? Very good. Third is no self-incrimination. Now, person was consuming alcohol, now caught red-handed, and it is 15th of February because it is breakup day, right? Person is consuming alcohol, it is banned. Now, the officer catches him and says, tell me your name. They say, no, self-incrimination. It is not there. Certain things are mandatory to be provided. For example, giving your name, giving your signature. For example, you are going on the roads in Delhi and the officer says, blow in this device, and say, no self-incrimination. No, this is not the case, because these are necessary samples that has to be provided. Is it clear? So necessary samples are to be provided. You cannot deny giving your blood sample where there is a doubt that the person may be under the influence of alcohol. You cannot deny giving your name. You cannot deny doing your signatures. Is it clear? And that too are available only in criminal acts, certain rights, and only for judicial punishments. Article 20 is clear to us. It's very simple yet important. Yes or no? Very good. Note this down. Only these things you need to know. Sir, can the cases be reopened in reference to double jeopardy? But when the punishment is given, if a person is getting second punishment, the lawyer will automatically say that my client has served the sentence. Otherwise, if this double jeopardy is there and you had an advocate, then your choice was wrong. Okay, you need to have a better advocate in such a cases. If your advocate is not saving you from double jeopardy, right? I can give you my reference. Separate crime, separate punishment. Let me give you another example of Shri Lalu Prasad Yadav. He ate fodder of different animals. So different crime, different punishment. Another example of Dr. Sant Shri Gurmeet Singh Ram Rahim Singh Insan ji. Separate crimes, separate punishment. Clear? Yes. For one crime, one punishment. For two crimes, two punishment. Is it clear? So in movies you must have heard it. One murder, one punishment. Two murders, one punishment. No, two murder, two punishment. Right? Do not study polity from movies. Otherwise, you will take a PIL in a subordinate court. That happened in Jolly LLB. A PIL was filed in a subordinate court, which is not allowed. Is it clear? Understood? Yes or no? After 20, which right will come? 21. Everyone has noted this down? Very good. Now, what does Article 21 say? The first thing that we will identify, it is for citizens or for all? All. Sir, why Article 16 is not for both citizen and foreigner? But Article 17, sorry. Article 17 is for all. Okay? Article 17 is for all, not only for citizen. Remember 15, 16, 19, 29, 30. Article 21, it is for all. What does it deals with? It deals with right to life or personal liberty. Very good. This is enough in this article that we need to know. What is the most important thing here? Article 21. Article 21. Why you all are so low on energy? Her, I know she is there here till since 11:30. Others? Huh? Why you all are so low? Tell me. History class. So history class, you should be learning history to secure your future better. That in future you do not have to study history again. Right? Because polity is most important and you should be having more energy. NCERT summary free. Now Article 21 talks about right to life or personal liberty. Right to life or personal liberty. This is the right. There is a restriction that someone can take away your right to life or personal liberty, because if you read right only this much and you said that then why there was a lockdown, right? This is the first time we have experienced lockdown in our country, and it was a violation on right to personal liberty, because it was our choice when to go out, when not to go out, but you are not allowed to go out. It was a violation of personal liberty, but the state is allowed to do that through procedure established by law. Procedure established by law. It means you have right to life or personal liberty, but that right can be taken by the state when they are following a procedure established by law. This much is Article 21. That's it. Here, do you need to understand what is right to life? It means anything that is affecting your existence, that is your right to life. Court has elaborated it further. Court has said that the right to life not only includes the existence, but it includes the existence with dignity, right? Dignified existence. Right to personal liberty, you all know that's something that we want to have in our personal life to develop ourselves fully. You know liberty now? Now we need to understand what is procedure established by law. Simplest question, from where we have adopted procedure established by law? Japan. From where? Japan we have adopted. And what is the meaning of procedure established by law? What is the meaning of procedure established by law? We all are confused with this. We know that there is procedure established by law. We know there is a due process of law. But we are not crystal clear about the differences between the two. What is procedure and what is the due process of law? So, in India, the Constitution, answer this statement. The Constitution of India provides for procedure established by law. True or false? True. Because this is what is written. Constitution is providing it. In India, both procedure established by law and due process of law are applied. True or false? In India, both due process of law and procedure established by law are applied. True or false? True. Now, in India, how governance takes place? Either as per the provisions of the Constitution or interpretation of the Constitution. It is a clear provision that you have right to life or personal liberty, which can be taken through procedure established by law. But the Supreme Court has also expanded this by giving a doctrine called as the due process of law. Due process of law, what it is, from where we have taken this? We have taken it from the USA. So, procedure established by law and due process of, simplest thing, it means while there is a law found, understand it very carefully. Do not write, everything is written. Understand it carefully. Let us understand with an example. Very good. We are considering an hypothetical situation that there is a law that if you are 21 years of age, okay, if you are 21 years of age, you should be married. Hypothetically, we are taking this situation, okay. If you are 21 years of age, you should be married. Only one exception, that you should be a student. There is one exception, you should be a student, okay. Now, let us imagine a situation where we are living a life where everyone who is 21 years of age is married or a student. Now, you are walking on the street, right, and a person, an enforcement agency person met you and said, I think you are 21 years of age. You look more than 21. Show me your marriage certificate. You say, I am single. So, they say, okay, then show me your student ID card. Say, I am not a student. Okay. The next thing is, the person will be, or person is taken under detention as per the laws. What the officer has done here? Officer has followed the procedure established by law. Now, can that person's personal liberty be taken? Yes, because this is what the law is. That is the due process of. It means the executive is to be bound by the procedure. The legislature is not at all involved in it. Whatever the law the legislature has made, that law will be functional. But in due process of law, let us take the situation, you are walking, then a person met and said that you are looking more than 21 years of age, show me your marriage certificate. Then you say, Maha life, Maha choice. You simply say, because why should I show you the marriage certificate? Who are you to ask? If you can question it, they say, and the officer will reply, there is a law. Why there is such law? When you can ask these questions, then you are in the due process of law. It means you can not only question the procedure of the executive, you can also question the legislative wisdom, that why you have made such a law. Both the things can be questioned. That is the meaning of due process of law. Is it crystal clear now? The Constitution originally did not provide for it. Then there was a Maneka Gandhi case, and in that Maneka Gandhi case, the Supreme Court acknowledged the existence of doctrine of due process of law. So, at present we have both, but what the Constitution has provided for? Procedure established by law. Are we clear? Yes, no? Very good. So, here executive is only under the or executive can only be controlled, legislature is having a free hand. Here both executive and legislation can be questioned. Okay, this is due process of law and procedure established by. Write it as a note, not mentioned in Constitution. Not mentioned in Constitution. Okay. Not mentioned in the Constitution. Note this down, very, very important. This you have noted. This you have noted. Note this down also. Done? Any doubt in Article 21? Then what will come? 22? Yes, but this is not maths. This is polity. Now, there are so many questions from right to life also. Just understand, anything can come under the right to life. There is no limitation under the right to life. Because this is what we have studied in the book. We have to take it a step forward. Yes. So, right to life, anything can be included. For example, right to wear something, right to life. Right to listen to songs, right to life. Right to watch a movie. It is our right to life. Yes or no? Right to go anywhere. Right to, for example, if someone asks that if you want to walk on the streets, which of the following rights it includes? Right to healthy environment? No, walking on the street, which right it is? No, article I am asking. 19, very good. And if you are a foreigner? 21. So it means it depends what the question is asking, right? It depends what the question is asking, that whether it is talking about the citizen or a foreigner. Is it clear? So right to life is a very elaborative right. In this, something you need to remember. There is a right to privacy. Because Supreme Court or the UPSC have asked sometimes judgments. So right to privacy, which judgment? Puttu Swami case. Like due process of law came from the Maneka Gandhi case, so right to privacy may also come. So right to privacy, Puttu Swami case. Puttu Swami. Very good. Now, when right to privacy is under Article 21, what will be considered or will the right to choose your partner be considered under Article 21? Why? It reflects what? Your personal liberty or your privacy or your life? Life? Life partner means life? Very good. Personal liberty and privacy also, right? Before that, because the right to privacy has provided you freedom to choose your partner, right? Because it is a part of your privacy also, that it is your private life and you should not be getting interference from anywhere. Similarly, the decriminalization of 377, section 377, it has been decriminalized under which right? Article 21. Why? Because, now let us understand, because we have to understand polity in a very elaborative manner. A person was charged as a criminal under 377 because a person was involved in a intimate relationship with the same gender. Now, how the court came to know that this person was intimate? Understood? Had there not been any right to privacy as a fundamental right, maybe section 377 would not have been decriminalized. It provided the substance. So if a question comes, right to have a homosexual partner comes under which right? So it will be right to life, right to personal liberty, right to privacy. Okay, all the above. All the above. Are you getting my point? Why it is important? Similarly, one important doctrine was also given under this. The doctrine is right or doctrine of progressive realization of rights. Doctrine of progressive realization of. Okay. It is also elaborated under the Article 21. It means your right now cannot be narrowed down. If you have a right to privacy, in future you cannot have a judgment which is taking away your right to privacy. Now once you have right, you have it in perpetuity until unless it is not elaborated. The Supreme Court in the decriminalization of 377 case or the Navtej Johar versus Union of India case have established this doctrine of progressive realization of rights. Are we clear with this? Because the question may come from doctrine also. So this was given as a understanding of Article 21. With this we have had some understanding of Article 21. Note this down, then we will proceed further. Right to privacy is not mentioned in the Constitution. It is an interpretation of the Constitution. Okay. Now, right to information comes under which article? 21. Why? Because it is written in the book. Right? But the book, that's what I say again, books may have additions. Right? So, right to information is a legal right under RTI Act. It is a legal right under RTI Act. Clear? Very good. Now, right to property, question came. Right to property is which right? Legal. Let me ask you a question. Options also I am giving. Right to property is constitutional right, legal right, fundamental right, not a right. Right to property, legal right, fundamental right, or constitutional right, not a right. Tell me. Legal right, constitutional right, though both. Constitution, both constitutional and legal, both. Okay. So I have prepared one very good question from this. Let us discuss that question first. Okay. Then we will proceed. Today's answer this question. So 1, 2, both and none. Options are 1, 2, both and none. Answer this question. Good question. And it is not a past year. So if it comes, second is correct. Give me choice. Give me A, B, C, D. B. Very good. With reference to fundamental right and legal right, which are the following is or are correct. Both fundamental rights and other legal rights are protected and guaranteed by the Constitution. Very good. A person can directly approach the Supreme Court only for the enforcement of fundamental rights and not in the case of legal rights. While restrictions can be put on legal rights by the parliament, fundamental rights are absolute. The third is wrong. Option is also not there. Okay, this is the main purpose, not making the options. The making statement was the main purpose. Second is also wrong, because when there can be enforcement, you can directly go to Supreme Court for fundamental rights only. So second is correct. Second is correct. And first, both fundamental rights and other legal rights are protected and guaranteed by the Indian Constitution. Legal rights are not protected and guaranteed. Only fundamental rights. Tell me. The legal rights are protected and guaranteed by the Constitution or not? Statement is wrong. Okay. But why they are not? It's not because just we have read. Is that because legal rights are not guaranteed by the Constitution. Legal rights are guaranteed by the Parliament through their law. They are legalized by the laws of the Parliament. They are guaranteed by the parliamentary laws. Otherwise, all the rights which are functional, they should be under the ambit of the Constitution. Okay. And here also another thing is wrong. Both fundamental rights and constitutional rights. There are other rights out of the Constitution like fundamental rights and constitutional rights like right to property. Right to property is a constitutional right under Article 300A. Under Article 300A, it is a constitutional right. This year the question came from right to property. Yes, there was a question from right to property, but that option did not have constitutional right. Otherwise, that would have been correct. Let me see, I have this question or not. I'll bring that question again. So, we'll be discussing that also. Now, we have understood Article 21. Any doubt in Article 21? Yes, no? No. So, after 21, what will come? 21A. What does Article 21 talks about? What does Article 21A talks about? Tell me. It talks about education. Just education, word, only one word, education. It's between 6 to 14, only two words, education and 6 to 14. Very good. You have to read it, because this is what, see, everyone is reading the Constitution. Civil service aspirant also, and the top lawyer or the advocates of this country. And the only difference between us and them is they read even a comma with the interpretation of the Constitution, and we read Article 21A, education. So Article 21A provides for, read it again. First line. State shall provide. First thing, it is not the responsibility of everyone, it is only the responsibility of the state. This right is only vertical. You cannot go in the street and say, give me compulsory and free education. Article 12. Article 12. State word means Article 12. So it state means union, state, panchayat, municipalities, PSUs, or a private organization working on the government contract. Is it clear? So Article 21 says state shall provide. Is it available for citizens or for all? All. So state shall provide citizens? No. State shall provide this much. Free. It means the education should be free and compulsory. The education should be free and compulsory for every child. For every child in the age group of 6 to 14 years. Okay. So 6 to 14 years. That's it. That's it. As provided by the law or in accordance with the law. It means it is not self-executory. There has to be a law for the provision of this education. Now, when you see the word A, B, C, that means it was not in the original constitution. Because had it been in the original constitution, it would have been 22, not 21A. It means it was added through some amendment. Which amendment act? Which amendment act? 86 Constitutional Amendment Act 2002. 2002. Clear? So it was added. 86 Constitutional Amendment Act also made other changes. It means matter of Article 45 was elaborated and changed, which was reading the right to education. Now it reads early childhood care and education. It also added one fundamental duty, Article 51A, which one? 11th. So just remember 10 and the 11th. A, B, C, D, E, F, G, H, I, J, K. Do not unnecessary cram things. When you know counting, so it is the 11th one. Article 51A, K. Clear? Very good. Now let us elaborate it further, because this is what we all know. What if a good question comes? Now RTE, because when it comes to the policies of the government, the 3 or 4 areas are favorite of the UPSC: education, health, skill development and human resources. Most of the questions are asked from this area only. So it is education. RTE has been asked, right to education has been asked. So one important point here is RTE was in which year? Right to Education Act, which year? Very good. Sure. 2002 to 2009. 7 years. No one took a case to the Supreme Court that why I don't have this right. Genuine question. For 7 years, these children are waiting. The child was born and now this child is of 7 years. Then where is my school? Because in 2002, the family thought now we can have children. Because the biggest burden parents think is of education of children. Now they know that it's free. They had a child, but now no school, no right to education. But why it was not implemented? And no one took that case to the Supreme Court. Why? Because there is a doctrine of suspended animation. This right was there, but it was put under a veil, right? Because when the law is there, then only it can be implemented. Clear? So there was a doctrine of suspended animation. Is it clear? Note this down. Yes? But a horizontal means state is providing when you have to ask any doubt from the state, when it is restricting the state, when it is only affecting the state, that is vertical. मतलब बी देखिए वर्टिकल का मतलब है कि हम आपस में नहीं, हमारे पास वो राइट स्टेट और हमारे बीच में. हॉरिजॉन्टल मतलब हमारे सबके पास वो वाला राइट है. जैसे कि अगर स्टेट अनटचेबिलिटी करेगा तो भी वो क्राइम है, हम लोग अनटचेबिलिटी करेंगे तो भी वो क्राइम है. ठीक है, लेकिन स्टेट अगर एजुकेशन के लिए मना करेगा तो वो क्राइम है, या इट इज अ वायलेशन ऑफ द कॉन्स्टिट्यूशन. हम मना करेंगे वो वायलेशन ऑफ कॉन्स्टिट्यूशन नहीं है. ठीक है, not here. Constitution does not provide for it. RT provide for it. Okay. Private institution is itself an institution. Okay. It is working, a private institution working on a government contract, that is recognition. Except minority, all have to give. Except minority, everyone has to give. Okay. Why minority? Because minority are administering their own institutions. Clear? Note this down, then we'll proceed further. Done everyone? Right. Today we have to complete fundamental rights and the questions from fundamental rights. Okay, let's see. Till when? I am also not in a hurry. Okay, because I reach home at 10, then also I'll get beep beep. If I'll reach at 11, then also. So no issues. So let us discuss. We have to complete fundamental rights, right? Done. After 21A, what will come? 22. Article 22 protects us from arbitrary arrest and detention. Now, Article 22 is having two parts. It protects from the arbitrary arrest and detention, right? But how do we know that arrest is for something that we have already done or something that we are planning to do? Crime can be both. Something you have already done, a person is arrested for that. A person is planning, okay? A person is planning to do something. That is also a crime, right? You know that? That having a conspiracy or being a part of a conspiracy, that is also punishable, right? So, there is punitive. Punitive means crime is committed. Then there is arrest and detention, and there is preventive. Preventive means the crime is not yet committed, then detention is there. Now understand the rights here that we will be discussing, are for punitive detention. These rights does not protect you from preventive detention. Is it clear? For example, the rights that you have, you cannot ask when someone captures you and says nothing. Okay? But here you have certain rights. The rights for punitive detention are available for citizens, and friendly aliens. Citizens and friendly aliens. The rights under preventive detention are available for all. It means the rights that we are about to discuss now. Do not write understand, I will give you time. See, when I give you time, then what you all will do? Right? It's better listen, and at that time write. Understood? These rights are available for citizens and friendly alien. These rights are available for all. This what we will be discussing will not be available for the enemy alien or any crime under preventive detention. So what we are about to discuss is not available for enemy alien. Example of enemy alien: Pakistan, whole Pakistan, or terrorists. So terrorists to have this right also they do not have. Enemy alien means any country with which India is engaged in a war. Pakistan is not enemy state, because right now we are not engaged with a war, but because we always have conflict with Pakistan because of because of the unsettled border, that is why we consider it as an enemy state. Otherwise, the definition of enemy state is the country with which India is in a state of war. Is it clear? So it is not available for enemy aliens, be it Pakistan, be it China, be it any other country. Understood? You know what we are discussing will be available for whom? Very good. Now let us discuss the rights under Article 22. Now we are going out. After the class, we go either to our houses or we go to have a sip of tea. Now you are sitting there and suddenly a PCR comes and asks you, come with us. Now what would be your initial response after saying sorry? First response will be sorry uncle or auntie, right? And you will imagine when I will become an IPS officer, I will show. Is what imagine. But as a student of Constitution, what will be your first response? Why? Yes or no? So your first response, why? Now how you can ask this question, why? Because of the Article 22. Article 22 give the right to be informed. Right to be informed for the reasons why you are being arrested or detained. Okay? First right you have informed for reasons. Acha, which language you all don't understand? English? You don't understand? No, don't lie. I am saying don't write, understand. I am saying don't write, understand. Right? Because this is very important. Article 22 is most confusing article here. And if you don't understand it, you will be confused. And blame will come to me, you will do beep beep to me. So, understand. Inform for the reasons. Now, you were sitting, PCR came and I told, come with us. You said, why? They told you. You said, okay. Now, what will your next response? What will be your next response? After sorry again. That I need to talk to my lawyer. Yes or no? We all have watched English series. Yes or no? Breaking Bad you have watched. Talk to my lawyer. So, you will be having a right to have legal aid. Right to legal aid. Now, you have called your advocate. Advocate said, okay, let me talk, you stay silent. And what will happen? You will be presented in front of a magistrate. You will be presented in front of a magistrate within how many hours? Before a magistrate. Judicial magistrate? 24 hours. Do not, while it is happening, do not think it's 24 hours, I have not reached to the magistrate, I can run. Travel time excluded. Okay? Travel time is excluded. Okay? Understood? These 24 hours do not include travel time. Then, if the magistrate has not given, have not ordered for further detention, the person will be set free. Detained only if ordered by the magistrate. Okay? Then only the person will be detained further. Otherwise, the person will be allowed to let go. Understood? Yes or no? Very good. These are the rights you have under Article 22. You have the right to be informed, the reasons for the arrest or detention. You have the right to have legal aid. You have a right to be presented in front of a magistrate within 24 hours, and you have a right to be set free if the magistrate has not ordered for further detention. Are we clear? Yes or no? Now, does it include judicial magistrate only, or it includes executive magistrate also? Tell me. Because questions have come in 2021, we need to involve those also. What is judicial custody? What is detention? What is parole? What is bail? All these questions are now coming. Tell me, it includes judicial magistrate only, or it includes any magistrate? Now you will say any magistrate. Magistrate is judicial only. Yes or no? No. Executive magistrate also there. You all are preparing for civil services. Hopefully someday you will also be the executive magistrate initially, then you will be the district magistrate also, because the executive magistrate begins from the post of Naib Tehsildar in the state. Now it includes both, because it is not necessary that every crime or every arrest is for a criminal offence which is to be tried by judicial magistrate only. It means not every arrest is non-bailable. Bailable arrest means judicial magistrate only. That the judicial magistrate will only give the bail. The executive do not have that power. That is the meaning of the bailable offence. That executive do not have power, only judiciary can give the bail. Non-bailable means executive can also give the bail. Understood the difference? Otherwise, generally as a lay person you believe non-bailable means the person will not be out. The person is gone forever. The person will be breaking stones there. Yes or no? This is not the meaning of non-bailable offence. Non-bailable means the person can only get bail from the judicial magistrate. Bailable offence means executive can also give the bail. Are we clear with this? Very good. These rights are available for only citizens and friendly aliens. Now it is only there when you have committed a crime. But when you are taken for preventive detention, and for example, this will not happen with you. It may happen with me. I am going walking, having a sip of tea. Comes, PCR comes, come with me. Okay. So after sorry, what will be your first response? Tell me the reason. And they put a socks in my mouth and take me away. Why? Because in preventive detention, none of these rights are available. Okay. But there have to be certain rights. First, please tell me why am I detained? Please. It means you have the right to be informed of the reasons if it is not affecting the public order. It means if it is affecting the public order, no reasons. Please, can I have legal aid? Yes. The person can be informed for the reasons. The person has right to have legal aid, and the detention can be maximum of 3 months. And it can be extended or reduced by a committee of High Court judges or an advisory board, because we should write the exact words. Advisory board consisting of High Court judges. Because everything you remember, but you don't remember it was which judges, High Court or Supreme Court, you will feel very bad. So the preventive detention can be for maximum 3 months. It can be increased or reduced by an advisory board consisting of High Court judges. Is it clear? Yes or no? Very good. This is what is 22. You have any doubt? You must have some doubt, because 22 is most complex. Article 35 we have read that the power to make any changes in the laws, it can be done only by the Parliament. Very good. Have you heard about the UP Gunda Act? Yes. Have you heard about the POTA? TADA? You must have heard about the Maharashtra Organized Crime Act, MOOC. They are state acts. So it means they all are violating the Article 35 of the Constitution. It is not so late. Let us go to Supreme Court. Don't you think it is a violation of Article 35? Because we have heard that Article 35 gives power only to the Parliament to make laws. Yes. Second thing, preventive detention is a part of the Article 22, which is under the chapter of fundamental rights. Huh? Contraries? No, under this preventive detention, because law and order is a state subject also. Okay. Law and order is a state subject. Policing is also a state subject. So state also have to ensure its security. Right. So for the laws with respect to preventive detention, both Parliament and state legislature is allowed. Okay. So we will write a note. Write a note. First note this down. When you have noted this down, then we will write a note. This you have done. Everyone has noted this down? You note down. दोस्त फिर भी अभी भी, हाँ अब ठीक है, था दोस्त, हाँ था तो ठीक है। हाँ नहीं नहीं, प्रिवेंटिव नहीं, क्राइम कर तो दिया। अगर आपको अपने दोस्त को देखते ही आपने उसे बंद कर दिया कि अगर ये पी लेगा तो कुछ ना कुछ करेगा, तो आपने उसको पीने से पहले ही कमरे में बंद कर दिया कि पी, खुल के खेल, प्रिवेंटिव डिटेंशन। हाँ तो प्रिवेंटिव नहीं है, प्यूनिटिव है। हाँ, पब्लिक न्यूसेंस क्रिएट करने के लिए पकड़ते हैं, ठीक है, पब्लिक न्यूसेंस एग्जीक्यूटिव मजिस्ट्रेट के पास भेजेंगे और वहां बोलते हैं दोबारा मत करना, ठीक है। हाँ बेटा, कुछ है ही नहीं ना राइट, सबको क्या, पूरी दुनिया को तो कुछ है का राइट, है ना, बिकॉज राइट टू इन्फॉर्म है, वो भी मना कर सकते हैं। लीगल एड है, प्रिवेंटिव डिटेंशन वाले को जब रीजन नहीं पता, एडवोकेट क्या सपोर्ट करेगा, है ना। और 3 मंथ्स तो मिनिमम है ही, मतलब मैक्सिमम है, 3 मंथ्स के बाद आदमी वैसे ही सुधर जाएगा, ठीक है। जिसके अंदर कौन सा होता है, अनलॉफुल एक्टिविटीज प्रिवेंशन एक्ट, यूएपीए जो है प्रिवेंटिव डिटेंशन के लिए ही है। नेशनल सिक्योरिटी एक्ट है, they got detained for a year also, but that is not preventive detention, that is house arrest. House arrest is for political reasons, one of the reasons, but you cannot, for the security of the nation, you may not tell the reasons. For the security, you may not tell the reasons, and that is why they were kept under house arrest for a year, more than a year, right? Understood? Any doubt? Still writing? Note down. Because this is very important. 22 is very confusing, and you know, whatever I told you, everything is there in your book. Everything is there in your book, but we skip it or we don't get it what they are trying to say. Understood? And there are also certain limitations in the book, and that is why there are different editions, and every year I write some mails that this change is needed. Sometimes it is accepted, sometimes it is not yet accepted. For example, I'll tell you places to places where still there is a mistake in the book, okay, even though you have the latest edition, okay, there is something which will be there in the 8th edition also, but I want you not to purchase the 8th edition. By then you should be in the services itself. Clear? Very good. Write that note. Write that note. For preventive detention, both for preventive detention, both Parliament and state legislature, for preventive detention, both Parliament and state legislature can make laws. Both Parliament and state legislature can make laws. Okay, is it clear? Now after 22 we complete right to freedom. After right to freedom what comes? Right to exploitation. Yes or no? Yes. Right to exploitation or right against exploitation? This also you have noted? Note down. And in my class, if you all feel hungry, you can bring something to eat also, okay, because our purpose is to study, nothing else. Done? Now let us proceed further. After 22 we come to right against exploitation. Right against exploitation. It includes right under Article 23 and rights under Article 24. Article 23 deals with prohibition of human trafficking and forced labor, that is also called as begar. Okay, forced labor and begar. It talks about the prohibition of or abolition of child labor. Yes? Yes or no? Yes, beta, forced labor only. Begar means forced labor. It's not beggar, it's begar. Bonded labor. Salary milling, forced labor, bonded labor, it not always means free. Limited salary also. Begar is a practice of bondage labor. Okay, it was a practice that people used to follow previously. That now your father took the loan from me, the child has to also pay. Bandhuwa mazdoor, bonded labor is bandhuwa mazdoor. Okay, example of bonded labor is Katappa of Bahubali. Katappa's father made a promise. If you have watched the movie, Katappa's father made a promise and Katappa has to follow that. Example of generational bondage. Clear? So that was forced or bonded labor. But forced labor is in the present time it is banned. It means you have to tell these terms and condition before giving the employment. After the employment, for example, you employ someone and you say, okay, we'll decide later, we'll decide. And later on, you give best wishes, okay, in return of salary, that my wishes always come true, and you give them best wishes. So that will be forced labor. But if you initially tell, we'll give you best wishes and come work with us, that is not forced labor. Okay, understood? So abolition of child labor. Now the ban on human trafficking is in a way that the state will determine in accordance with law. Now state has for that reason passed Minimum Wages Act. State has passed the acts like the Protection of Civil Rights Act or the Prohibition of Untouchability, it was renamed. These are the acts. For the abolition of child labor, the state has passed the act like the Prevention of Child and Adolescent Labor Act or Prohibition of Child and Adolescent Labor Act. Is it clear? Will you answer a very good question? According to the Constitution of India, a child cannot be employed if he or she is below the age of 14 in an hazardous industry. According to the Constitution of India, a child who is below the age of 14 cannot be employed in hazardous industries. True or false? Now, false or true? True. It means 14 years of age of employment you can give. A person who is 13 you can give employment. But you all are saying it's true. I am saying that according to the Constitution of India, a child below the age of 14 years cannot be employed in hazardous industries. So Constitution is saying below 14 other they can be employed. Only hazardous is banned. Tell me, true or false? True? Still true? Before 14, yes, but I am saying Constitution says below 14 hazardous mein you cannot employ, but that does not mean you can employ below 14. Constitution saying ये तो करना ही नहीं है, ठीक है, गवर्नमेंट ने बोला ये भी नहीं करना है. It means verbatim क्या Constitution में लिखा है that there is a ban on employment of children below the age of 14 in hazardous industries. इसको false मत करके आना, Constitution में लिखा है. समझ में आया? कॉन्स्टिट्यूशन में वर्ड लिखा है देयर इज अ बैन ऑन एम्प्लॉयमेंट ऑफ चिल्ड्रन बिलो द एज ऑफ 14 इन हजार्डस इंडस्ट्रीज। दिमाग लगा के नहीं 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 सब में बैन है, कॉन्स्टिट्यूशन ने नहीं किया है। देयर इज अ बैन ऑन एम्प्लॉयमेंट ऑफ चिल्ड्रन इन हजार्डस इंडस्ट्रीज एज पर द कॉन्स्टिट्यूशन, लेकिन देयर इज अ बैन ऑन एम्प्लॉयमेंट ऑफ चिल्ड्रन इन एनी इंडस्ट्रीज एज पर द प्रोहिबिशन ऑफ चाइल्ड एंड एडोलेसेंट लेबर एक्ट। समझ में आ गया? मतलब कॉन्स्टिट्यूशन सिर्फ 14 से नीचे हजार्डस में मना करता है, ठीक है, लेकिन अलाउ नहीं करते हैं। ये नहीं अलाउ किया, बैन किया कि ये तो कर मत देना, ठीक है, भस्म कर देंगे, है ना। उसके अलावा गवर्नमेंट ने बोला ये भी मत कर देना, कॉन्स्टिट्यूशन ने भस्म करवा। समझ में आया? बिकॉज कॉन्स्टिट्यूशनल, इफ इट इज वायलेटिंग एनी ऑफ द फंडामेंटल राइट, आर्टिकल 13, दैट लॉ विल बी गॉन, null and void. Understood? Yes, no? Very good. This is article 24. This is article 23. Now, when you say that there is no forced labor, there cannot be any bonded labor. In colleges, you are participating in National Social Service Scheme, where you are forced. Yes or no? For marks. Yes, or you were forced to do something that you would have never done. Standing in front of a metro station saying, would you like to donate? Have you all experienced this? Now let us go to Supreme Court. ले ले उन सबका बदला, बताइए। No, because Article 23 does not put a limitation on the state to provide a compulsory service. Article 23 cannot stop a state to provide a compulsory service without or with some amount, but there cannot be any discrimination on the grounds of religion, race, caste and class. The word class is only mentioned under Article 23 in the fundamental rights as a discrimination. So the state cannot discriminate on the grounds of religion, race, caste or class while providing compulsory employment. Is it clear? It means forced labor ban है, लेकिन government or the state if wants can put a compulsory service. For example, doctors जो third year student थे MBBS के, compulsory service बोली थी कि during the COVID times you have to work, कोई ban नहीं है, लेकिन the state cannot discriminate on the grounds only of religion, race, caste or class. It means female doctors मना कर सकती थी, बिल्कुल, because state अगर बोले कि only male doctors will be coming, not female doctors, state को कोई रोक नहीं सकता, because sex is not a limitation which is not allowed. Discrimination on the grounds of sex is allowed under Article 23. Is it clear? समझ में आया? Yes or no? Very good. So this is Article 23 and 24. So now you are clear with right to exploitation और right against exploitation. ध्यान से लिखना, यूपीएससी कभी कभी मजे ले जाते हैं. Article 24 talks about right to exploitation. आप सही करके आ जाओगे. Right against exploitation है. Are we clear? Very good. Now after 23, 24, what will come? You want to note this down? Yes, note this down. Compulsory. Actually, that the compulsory service to be a part of political rally, not allowed. Anything can come, but you know that being a part of a political party rally is not a public purpose. Okay, because otherwise state can allow that also. There was sometimes notices to the district magistrate. Recently there was a notice, that was an order to the state road transportation, I will not tell the state, that you have to send these many buses for political rally. As a civil servant, you may not follow that order also, because it is not under Article 23, a compulsory service. Is it clear? Yes or no? Very good. Now when you know 23, 24, let us go to right to freedom of religion. Right to freedom of religion. From Article 25 to 28. 25 to 28. Now this is very, very important. Is it clear? Why? Because it is always in news. It is always in news. That is why it is important. But this year, why it is more important? Because of first? No. Because of passing of anti-conversion bills by many states. Wearing hijab or not, it is not the first time. Previously, the Muslims, they cannot have a beard if they are in the defense forces. That was given a judgment by the Supreme Court. So it is not the first time that the doctrine of essentiality has been used. But so many states have passed anti-conversion bill, anti-religious conversion. The latest one is Haryana. That is why this becomes important. Understood? Because UPSC don't ask always which is trending. Otherwise, UPSC would have asked how many types of badam are there, kacha or pakka. So, it is not always that UPSC asks what is trending, but UPSC asks basic from those questions. 25. What does Article 25 deals with? It provides the right to conscience, practice, profess, and propagate religion. It provides right to conscience, practice, propagate, and practice religion. These all are rights that are under Article 25. It means if you are an individual in this country, you are allowed to have any conscience. It means if you feel there is something in this, you are allowed. You have this lucky pen. You must have heard this. This is my lucky pen. This is your conscience. Otherwise, it is not lucky, because if you don't know anything, all the pens for you are unlucky. Yes or no? And if you know it, all the pens for you are lucky. But we generally have this conscience that this is my lucky pen. And that is why we pray to our pen also before entering into the examinations. Why? Because you also have the right to profess your religion. You can regularly pray to your pen because you have the right to practice also. And you can also say, you should have a lucky pen. It has changed my life. You are propagating. You have all these rights. And you all these things you can do as an individual or a group also. Let me give you an example. There are various places in India where you have certain gods. Either you say Chhadi wale Baba. You ever heard this? Or there is a Bullet Baba. This is the conscience. People believe that this thing is protecting their region. Conscience. People, they come and give their visit. Profess. People, they practice this regularly. And people propagate it that there is a, because if I have heard that there is a place in Rajasthan, there is a Bullet Baba and there is a temple of it, it means it is propagating also. And it is allowed constitutionally. You have all these rights. As an individual, and as an individual and as a group. Is it clear? Yes or no? No? But can you do anything as per your conscience? Because someone have this kind of conscience also, no? If I cut my hand before the examination, I may get good marks. Right? Now you have only one hand. You need to practice it regularly. So Then tomorrow you will profess it by cutting your roommate's hand. Your paper went fine. Third day you have to make it as a practice, because in mains there are 5 days that you have to go. You need third hand. So what you are doing, you are practicing it regularly so that you can do it very fast. And now you are propagating also when you cut your hand. But don't you think that is dangerous? Why? Because that is dangerous from the point of view of other fundamental rights. It's my right to cut my own hand. How can you cut your own? Cut my hand. It's my right. It's my life, my personal liberty. It means other fundamental right to equality also. Right to personal liberty, right to freedom of speech and expression, because other person might be having a conscience that I want to bang my head before the exam. Understood? Are you getting my point? That there can be certain destructive activity which is banned, because that may be either violation of other fundamental rights or health or morality. Right? These are reasonable restrictions. It means if a question comes that right to freedom of religion under Article 25 is inferior to other fundamental rights, true or false? It is inferior to other fundamental rights, true or false? True, because other fundamental rights, if they are being violated through Article 25, Article 25 can be restricted. It is the right which is not absolute, rather it is having a very strong restriction, that your right to freedom of religion is not above your other rights. Clear? Yes or no? Very good. Now there is a ban on freedom of conversion. Is a ban on or right to conversion. Bills are there. It is violating which are the rights under Article 25? Because there are 4 rights here, na? Conscience, practice, propagate and profess. So forceful conversion is wrong, it is unconstitutional, right? So forceful conversion, if there is a bill for it, why there is a bill? Because forceful conversion was violating which of the bill or which of the point here? Conscience. It is violating right to conscience. So the right to forceful conversion or forceful conversion are violation of right to conscience. Are we clear? Article 25 is clear to us? Yes or no? Note this down. The actual polity will start from tomorrow. Till fundamental duties, we are just discussing important topics, but actual polity starts from the president. Right? So do not think polity is this difficult. Actual interesting polity is from tomorrow. Done? Everyone? Very good. Oh. Note this down. Article 21 violation. Delicate 2, if it is banned because it was affecting the right to life. Right? But it is allowed. Yes? this year it started, and rather the movie on Jallikattu is considered as a very extraordinary creative work, though I have not watched it, but I am planning after your classes I will watch. Okay, you have watched? Good work. So note this down. This is only for filler. This we have already done. Very good. Now Article 26 comes. Article 26 provides the right to administer religious institution. It provides right to administer religious institution. Do you need to know what is a religious institution, denomination or sect? It is something, a group, right? It means what we need to know, Article 26 is a right of a group. You cannot say, I am starting my own temple, because if it is the case, then whatever number of Hindu households are there in India, they will be the number of temples in India, because every individual can have their own religious institution. Then no one will pay income tax, because religious institutions income is tax free. So it is a group right. Okay, to administer, manage, establish. It is in this order: establish, manage and administer. They have the right to have their religious institution. Religious institution. Okay, understood? But there can be limitation. There can be limitation on the grounds of health and morality. What? Health and morality. Another restriction? Tell. Public order, health and morality, right? The condition most important is it is not having that limitation that the other fundamental rights, if they are violated, this right can be restricted. It means right to religious administration is not an inferior right. It is a right which is having equal standing with other rights. Now you know why Jallikattu was not banned under Article 25, because it is a religious practice and it is a group right. Okay. No, but it is not violating. It is saying if any of the religious institution is violating health or morality, then that religious institution will be stopped. For example, there was a practice, or there is a practice where people, in order to enter into a religious institution, they have to give their blood. Okay. Health and morality also. It is immoral to ask for someone's blood. Yes or no? It is immoral. Okay. So such religious institutions can be shut. Public order. For example, during the COVID-19, the religious institutions were shut because that was related to health and public order both. Clear? So that is Article 26. Note this down. It is not, it is inferior to other fundamental rights. Question or revision? Yes. 26 does not have this reasonable restriction. Okay. Everyone has noted this down? Very good. Now let us go to Article 27. What does it say? Now I am challenging you, you will not tell it correctly. Tell me. I am challenging you, will not tell it correctly. Tell me. What is Article 27? What does it talks about? What does it talks about? Very good. Very good. Now I am correct that I challenged you. You did not read it right. Read it again. Read it again. नहीं क्या है सेकंड लाइन क्या? नहीं अभी भी नहीं समझ. आप बोलो चैलेंज देख रहे हो कि आप लोग के सामने नोट्स है फिर भी हम सही नहीं बता पा रहे. बताओ. वो वर्ड आप इग्नोर कर रहे हो. पर्टिकुलर वर्ड लिखा है. पर्टिकुलर वर्ड इज देयर. There can be religious tracts. If a question comes, there cannot be a religious tracts in India, true or false? False. There can be religious tracts. But there cannot be a religious tract for the promotion of a particular religion. और हम लोगों के सामने लिखा है particular, हम लोगों को मतलब ही नहीं है. Yes or no? So, the Article 27 is saying no tax can be levied. आप समझ रहे क्यों इतने कॉन्फिडेंस से बोला था 90% क्वेश्चन सही करवाएंगे? क्योंकि पर्टिकुलर वर्ड ही यहां इंपॉर्टेंट है. नो टैक्स कैन बी लिवाइड. ठीक है, इसलिए बहुत ध्यान से सुनने होते हैं सारे वर्ड्स. आई लाइक यू के आगे बट भी सुनना होता है ना. एज अ फ्रेंड आई लाइक यू माई फ्रेंड. आप खुश. ठीक है, लेकिन बट इज इंपॉर्टेंट. अगर आपने सुना आई लाइक यू एंड यू आर माई फ्रेंड, उसका अलग मीनिंग है. राइट? यस और नो? सो लिवाइड फॉर द प्रमोशन ऑफ पर्टिकुलर रिलीजन. क्लियर? कोई दिक्कत, कोई टेंशन इसमें? Very good. यानी कि can there be a tax for the promotion of all religion? Yes. Okay. समझ में आया? किसी भी सेक्युलर एक्टिविटी के लिए टैक्स लग सकता है. फॉर एग्जाम्पल यू गो टू अ टेम्पल, देयर इज अ पार्किंग. फॉर पार्किंग यू आर पेइंग द फीस. ओके, यस, कोई दिक्कत नहीं, बिकॉज सेक्युलर एक्टिविटी है. गॉड डिड नॉट टेल अस टू कम इन अ कार. यस और नो? मान लीजिए आप वैष्णो देवी जा रहे हैं, हेलीकॉप्टर से जा रहे हैं, कहेंगे नहीं आर्टिकल 20 कोई टैक्स नहीं देना, सिर्फ पैसे हेलीकॉप्टर के लो, नो सर्विस चार्जेस. बट वैष्णो देवी माता ने थोड़ी बोला हेलीकॉप्टर से आओ. अंडरस्टूड? दैट इज अ सेक्युलर एक्टिविटी. फॉर सेक्युलर एक्टिविटी देयर कैन बी टैक्सेस, इवन फॉर अ पर्टिकुलर रिलीजन. Even for a particular religion. Secular activity, that is the fees that you are paying. For that, will you be paying taxes also? But you are not paying it for the promotion. It is a service that you are getting. It is not for promotion. Understood? You do not see the ads on television saying, now visit this temple with VIP entry, star mark, other charges extra. You do not see such advertisements. Why? Because that will be a promotion of a particular religion. Are you getting my point? For the services that you are taking, for that you can have certain charges, because that is not a part of the promotion of religion. It is a corridor. Okay, it is a corridor that is for tourism purposes. It is not promotion of the religion, it is for the tourism promotion. Okay, now see, that is the main point of view. Word secular here does not mean separation of religion. It means utilization of religion in such a manner that every religion is equally respected from an equal distance. Right? Because in Chardhanata, along with this, we have a Buddhist circuit also. It is also for the religion, but tourism purposes. We have development of Nalanda University also, but for tourism purposes. Is it clear? Clear? Article 27 is clear to you? Very good. Note this down. What important thing we will note down here? Particular. Shall we continue? Now, after 27, there is article 28. What does it say? What does it says? Article 28. What does it says? First, tell me. Ban on religious instructions. Ban on religious instructions. Instructions in educational institution. Yes or no? Very good. If any religious instruction has to be provided, it can be provided only with the consent of the person concerned or the guardian. This article cannot stop any institution that is specifically established for religious instruction. For example, you started an institution to give religious instruction, and when you are not allowed, what is the point of having that religious instruction? Okay. For example, there are schools like the Saraswati Shishu Mandir or the Gurukuls or the Madrasas we have. They are established for providing religious instructions. And if you are stopping them, what is the purpose? Call them public schools. Is it clear? Second, it is not applicable for minority institutions. Okay? So it is not applicable. Okay, guys? Yes or no? This is Article 28. Done? Done? Now we have completed article 28 also. Now in this article 25 to 28, you need to understand a doctrine of essentiality. Okay? Doctrine of essentiality means the courts, they can interpret whether this activity is essential for the purpose of the religion or not. If that activity is not essential, the court can declare that as a non-essential practice and it will be not considered as a part of your conscience, practice, profess and propagate the religion. For example, the recent judgment by Karnataka High Court that hijab wearing is not a part of the essential religious practice. Clear? Because as per the Muslim law or as per the Sharia Act 1927, a person is considered as a Muslim who believe in one God and who believe that the Prophet Muhammad is the only messenger of God. Other than that, as per the Supreme Court, is open to interpretation. This is a essential practice. Similarly, the people who follow Sikhism, they have essential practices where they are following the 5 important details provided by Guru Gobind Singh Ji. The person is wearing a kada, the kacha, the person wearing a kirpan, the person is not cutting their hair, and a person is also carrying a kanga. These are the 5 essential practices. For example, a person is only allowed to carry a kirpan when other 4 are being followed. Okay, they are essential in total. You cannot say that I follow this religion, that is why I am allowed to carry kirpan. The question can be asked, what are the other essential elements that you are following? Okay, are you getting this point? Very good. So This is the practice, that is a doctrine of essentiality. Supreme Court. Supreme Court or High Court, it means the courts. For example, there is the Anand Margis. Anand Margis, they used to dance with skull in their hands. So it was declared as a non-essential practice. Similarly, there is a practice of female genital mutilation by the Dawoodi Bohra community. It can be declared as non-essential. Similarly, the practice of Sallekhna, it can be declared as a non-essential practice in Jainism. Sallekhna or Santhara. Okay, these are the names. So there can be discussed and identified as essential or non-essential practices. For example, the practice of sati. If it was there, if Dr. Raja Ram Mohan Rai did not have worked hard to ban it, if it was there in the independent India, it would have been declared as non-essential practice. But the system, non-essential practice. Because if wearing hijab is essential practice for one religion, the having parda can be also considered as a essential practice, but that will be violating the right to equality. Are we clear? So that is the application of doctrine of essentiality. Is it clear? This is not what I am saying, this is what courts are saying. Okay, whatever I say is what is there in the interpretation of the constitution. It is not essential as per the code. If the religious believers believe it is essential, they can always represent it in the Supreme Court. What Supreme Court will say, we'll teach. Because for us, that is the law. And we are here to discuss only whatever is legal in this country. Is it clear? Yes or no? Where? Yes, beta? See, if you say wearing hijab is my right to liberty, then you will say wearing shorts is also my right to liberty in school. You say not wearing shoes is also my right to liberty. If you interpret it under Article 21, school uniform is a violation of your right to liberty, because it will then open a wide range of questions. No student wants to wear uniform in school. Yes or no? So that is why it cannot be interpreted under Article 21. Is it clear? Understood? Very good. Because if you are saying it is a part of your right to life and liberty, then not wearing school uniform can also be, and the purpose of uniform can be gone. Clear? Article 28 is clear to you? 25 to 28 is clear to you? Yes or no? Very good. Now after 28, which article comes? Article 20. This is cultural. Again, challenge. You will not be able to tell me the correct interpretation of Article 29. Open challenge. I will also wait for few seconds for the online students, if they are able to tell the correct interpretation of Article 29. Educational rights. 29 and 30. These are available for all or only for citizens? Citizens only, because 29, 30. Very good. Article 29 is available for citizens or minorities only? 30 is available for citizens or minorities only? Article 29 and 30. Only minorities? Tell me. These are minority rights, right? So they are available only for minorities? Linguistic and religious minorities? Yeah. Article 29 is available for all citizens. Because it reads, now I have given you the cheat code. So now you know how to read it properly. Right? When it is written any section of citizens means any section. It means if I want to have my distinct language, script or culture, I have the right to conserve it under Article 29. Yes or no? Why? Because it is available for any section of citizens. It means it is not available only to minorities. We generally believed that it is available only for minorities, yes or no? Rather, the Constitution writes Article 29 and 30 as protection of the minority rights, but section of citizens. Is it clear? Now you can have your own distinct language. If you have your own language, you can protect it. Do not think that I am not belonging to a religious or linguistic minority, I cannot protect it. Okay? Very good. Now Article 29 also reads second statement that there cannot be discrimination against children for getting admission into the educational institutions. Yes, on the grounds of only 4 grounds are mentioned: religion, race, caste or language. It means if you are in an educational institution, no one can deny you admission saying that you belong to particular religion, you belong to particular race, you belong to particular caste or you belong to particular language. It means in educational institution, you can be denied admission on the grounds of sex. Yes, you cannot go to a girls school or college, say give me admission if you are a boy, right? Why? Because that discrimination is allowed.
Then why there is reservation in minority institution?
Because there is Article 30 also. They are not saying we will not give you reservation. They are saying admission cannot be denied. You can study in St. Stephen's College. It is a minority institution. You can study there. No one will stop you. Given that you qualify as per the cutoff.
State can say there would be only English medium schools.
Then it is not allowed. Only English medium schools are not allowed. Okay. Rather, if a state is saying, state means UP, Bihar, Maharashtra, they are saying that we will have only Marathi. For example, let us take Maharashtra example, that we will only have educational institutions teaching in Marathi language. You know what? President rule can be there in that state. Because center can give instruction that in the primary level, the educational institutions must be provided in the mother tongue also. Okay, mother tongue also. So that is the ground for president rule. Forget about any other thing. Is it clear? Now Article 29, it says any section of citizens. You have underlined section of citizens, written all citizens. Very good. Any section of citizens which have a distinct language, script or culture that may protect it. In the educational institution, no one can be discriminated on the grounds only of religion, race, caste or language. And it is about all the educational institutions. Okay. So it means, can a majority study in a minority institution? Yes. We have examples. AMU is not a minority institution. That is also a UPSC question. That what are the rights of minority institutions, who can declare an institution as a minority institution? AMU is not a minority institution. Why? It is not a minority institution because it is Central University. St. Xavier's where? Mumbai? Not sure about it, but AMU, because there was a controversy, it is not a minority institution. Okay. It wanted a minority tag so that it can get better benefits, but it is not it because it is a central university. If the state university is a minority university, then where will other students who are aspiring to become a student of that university go? If there is a particular reservation for the minority institutions only. Okay. St. Stephen's is a minority institution. Okay. Now Article 30 says the minorities, linguistic or religious minority. Minorities, linguistic or religious minorities, they have a right to have their educational institutions. Linguistic and religious minorities, they can have their educational institutions. That's it. Article 30. Clear? Article 30 is available for all? No. Only linguistic and religious minority. Only linguistic and religious minority. Are we clear? Yes or no? Very good. There, with this we complete till article 30. Now what is left? 32. We are not in a mental capacity to study 32 today, but we have to, some questions from yesterday's class are also left. Right? Yes or no? You don't remember it, but I remember. Right. Answer these questions. Answer these questions. Is it visible clearly to everyone? Achha, you all have questions, no? Practice question 1, 3C3. It means the yesterday's questions. Tell me. An Indian origin who is ordinary, what is your answer? Only 2. Okay. First is any citizen who is ordinarily residing outside India and holds an Indian passport. No, PIO does not have a passport. First is wrong. Whole citizen of India of foreigner registered under the Citizenship Act 1955. Okay. Third, a non-resident Indian person who is of any those ancestral Indian nature who is presently holding another citizenship. These are replaced. Right? 2 only is correct. B. Second question. Second question. D. Very good. Answer is C. Because the person who has migrated to Pakistan, if they are coming back, they cannot be allowed to become Indian citizen until and unless they are resettled under the government's notification. Okay, because it is saying after 1947, right, it is not allowed. Okay, first is wrong, and Article 7 does not allow for it. Answer is C, 2 and 3 only. Now, third question. Only when they are resettled, only they are allowed. Otherwise, they will not get directly Indian citizenship. Okay. This question third. B. Let us see.
नहीं, not correct.
Let us see. Cessation of a territory by the union to a foreign state can be done by an executive action. No, it is wrong. Can only be done by a constitutional amendment. So first is wrong. So answer cannot be B. Very good. The settlement of a boundary dispute between India and foreign state requires the constitutional amendment. Let us see. It may or may not. Let us see the third option. The acquisition and admission of a foreign territory under the international convention can be done by ordinary legislative action. Yes. Third is correct. Third is correct. First is wrong. It means A. 1 and 2 only. Answer is A. Order means simple majority. Amendment है 100 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, लैंड बाउंड्री एनक्लेव्स की बकायदा पूरा अमेंडमेंट किया. ओके देखिए सिंपल बात है, याद रखने का तरीका. रिमेंबर, अगर आपको कोई गिफ्ट दे रहा है तो थोड़ी बोलोगे मम्मी से पूछ के लेंगे, नहीं? अगर कोई गिफ्ट बोल रहा है कि हमें गिफ्ट दो, बोले मम्मी से पूछ के देंगे. यस और नो? दिस इज हाउ वी वर व्हेन वी वर चिल्ड्रन. कि कोई कुछ खिलाने को दे रहा है कि हाँ ले लो खा लो, अपने टिफिन में से कोई मांगता है, नहीं मम्मी ने मना किया. बिकॉज गिविंग योर टेरिटरी नीड्स कॉन्स्टिट्यूशनल अमेंडमेंट. बिना पूछे कैसे दे दोगे? बट कोई कुछ दे रहा, हाँ ले लो, क्या दिक्कत है, कौन मना करेगा? अंडरस्टूड? दिस इज व्हाट वी शुड रिमेंबर. एंड दिस इज नॉट गिवन इन द कॉन्स्टिट्यूशन, दिस इज गिवन अंडर द सुप्रीम कोर्ट्स इंटरप्रिटेशन ऑफ बेरूबारी यूनियन केस. कॉन्स्टिट्यूशन ने ऐसा कुछ नहीं बोला, सुप्रीम कोर्ट ने बोला है बेरूबारी केस में. इज इट क्लियर? वेरी गुड. बाकी करेंगे कल शुरुआती क्वेश्चन से करेंगे. ठीक है, विल स्टार्ट विद क्वेश्चन. या एक कर ही लो, दिख रखा आप लोगों ने, कुछ लोगों ने सॉल्व कर लिया होगा. तो ये वाला 4th क्वेश्चन लास्ट. थर्ड को स्टेटमेंट इज नॉट डन बाय एग्जीक्यूटिव ऑर्डर इंस्टेड ऑफ लेजिस्लेटिव प्रोसेस. बेटा ऑर्डिनरी लेजिस्लेटिव प्रोसेस से भी कर सकते हैं, किसी से भी कर सकते हैं. लेने के लिए ऑर्डिनरी हो, एग्जीक्यूटिव एक्शन हो, कुछ भी कर सकते हैं. 4th क्वेश्चन बी डी. बॉम्बे दिल्ली? बॉम्बे. वेरी गुड. A bill related to creation of new states require constitutional amendment? No. Article 4 denies that. Then prior permission of the President of India? Yes. Can be introduced in state legislative assembly? No. None of the above. B is correct. Okay. B is the correct answer. कितने बचे एक बार देख लेते हैं. लास्ट बेटा ये भी निपटाए देखी जाएगी. ठीक है चलो. डी दिल्ली. दिल्ली. सी. सी. Which of the following may result in loss of citizenship of an Indian citizen? Okay. If a citizen, correct ही पूछा ना? Correct पूछा. If a citizen voluntarily acquires citizenship of another country, बिल्कुल गई. ठीक है, तो फर्स्ट इज A, C और D. B तो गया. देखिए while whenever you are doing any questions, make sure you eliminate first. बाकी बातें बाद में, but make sure you eliminate first. So कहाँ तक? Okay, तुम you eliminate it first. हाँ ये काट दिया. Then if the citizen has ordinarily resident out of India for 5 years, oh 7 years. Remember, ये भी गया. Second is wrong. Second is wrong. C will be the answer. 1 and 3 only. But let us study the third state. If the citizen has shown disloyalty to the constitution, yes. In that case also, the citizenship will be gone. So answer will be 1 and 3. So this is what we had to do in the today's class. We will continue tomorrow. Okay. From 4 PM onwards, we have polity class tomorrow. Right. So in the first session, we'll be having polity class. I think this is what I remember. Otherwise, whatever schedule you have to come eventually. Okay. So you come as per your schedule. Okay. Thank you very much. We'll continue tomorrow.